I think that I will never see a webinar as good as a tree. Trees have leaves and branches and all, and this webinar is going to fall. Poems are made by fools like me, but only Gassman can screw up a webinar on TV. This is part 3 of asset protection from A to Z. It will make your head spin. Oh, I see you all out there. Don't worry, it only gets worse from here. Thank you very much.
Thank you for the introduction, and welcome to Asset Protection from A to Z. Although it's the Sabbath, so we've actually been going from Z to A. But this is part 3. I am Alan Gassman, and I apologize for that. Today, we're going to talk about creditor protection, and I'm going to turn off the screen and just have a little bit of a conversation about creditor protection. For those of us who are in this business, we find it to be very fascinating because the rules that apply as to when a creditor can reach assets and when a creditor cannot reach assets are interesting, somewhat predictable, somewhat unpredictable, and the strategies we use and the challenges that we face when a creditor actually shows up can be very much like a good chess game or a bad chess game, depending upon whether you like to play chess and whether you're the debtor or the creditor. Like anything that happens in the American legal system, it can be very expensive and very time-consuming for everyone involved. And I heard early on in my legal career that if you have a 100% chance of winning a lawsuit, it means that you have an 85% chance of winning a lawsuit because something could still go wrong. So I just wanted to point out that in my exuberance in both writing and presenting and representing people and representing business entities, we can talk about a lot of things that can work well, and we can make decisions based upon a lot of information. But it's really, really important to be thoroughly educated in this area. It is very important in any uncertain or touchy situation to bring in lawyers who are very experienced and knowledgeable in the debtor-creditor arena. That is usually a lawyer who does a lot of Chapter 11 bankruptcy work, because that is the most complicated type of bankruptcy work. That is usually a lawyer who practices in your home state, or at least you confer with a lawyer who practices in your home state. And that is hopefully a lawyer or other advisor who educates and offers a number of alternatives. There is no one miracle silver bullet that kills that creditor or completely protects you. It is usually going to be a combination of things. And if the law says ABC today, it may say DEG tomorrow. Judges change their minds, legislatures change the law. So we want to make sure that we use a conservative and layered approach to creditor protection. In addition, remember, Noah built the ark before it started raining. To say, oh, I'll just wait till the last minute. If something bad happens, I'll call this guy I saw on YouTube and he'll be able to protect my assets and that'll be no problem. Or, oh, I have $500,000 worth of insurance. That should settle almost anything. Well, those are absolutely wrong assumptions. Any debtor will be much better off doing the planning earlier rather than later. And if you're not sure about the advice you're getting, get a second opinion, get a third opinion, get a fourth opinion, but do so under the attorney-client privilege to the extent that you can. So I know that many of you have seen part 1 and have seen part 2. This is part 3. It only gets worse. I'm going to repeat myself a few times. I'm going to give you some new information. I'm going to be watching for questions. The questions box is right there. You click on questions and then you type in your question, and then I may answer it if I know the answer. I'll pretend not to see it if I don't. If you came on through the CPA Academy website, you're going to get continuing education credit as long as you answer 3 of the 4 polling questions. If you came in through my website, you have my sympathy because you won't get any credit, and this is probably not even a very good program. We do speak quite a bit in a lot of different places, but I have to say that one of my favorites is Saturday at 11. And next Saturday, I'm going to pull together my notes from the 57th Annual Heckerling Institute on Estate Planning. I was there Sunday night through Friday afternoon. I took some pretty good notes. I learned some things. Oh, I'm sorry. I forgot to share screen. Thank you, Brittany, for telling me to share screen and for taking the paper towel roll. Okay, so you have here some of our presentations. This is where I was showing you where to click to ask questions at the inverted question mark. And on the evaluation for this program, you can say, hey, he did not turn his screen on in time. I will never watch his presentations again. Anyway, my Heckerling presentation, January 28th, that's next Saturday. And then the following Saturday, Basic Estate and LLC Planning, Fun with Dick and Jane. Okay, so, oh, by the way, Saturday the 11th, we're going to talk about asset protection structures and stories, and then Dr. Gary Moskovitz is going to join us and talk about professional acceleration strategies, how to optimize your state of mind. Now, if you've heard the Sri Kumar Rao webinars I've done, or you've seen them, or you know about Sri Kumar Rao, Gary and I have both studied with Sri Kumar Rao, so this will be very interesting. Gary will start at about 11:50 on Saturday, February 11th. All of those are free. Thank you to Bloomberg B&A for giving Marty Shinkman and Jonathan Blotmacher and I a writing award at the Heckerling Institute. And there's a picture of us. Marty, as you can see, is very tall, and Jerry and Jonathan wore mustaches and Cossack hats in celebration of that presentation. When you get to the polling questions, which you must answer correctly or you'll be kicked out, we have just established the National Institute for Charitable Education. We think it's a nice name. And this is from Stetson Law School. Stetson Law students can now get their pro bono credit in law by writing for our books and presentations on charitable giving. So if you have any charitable related situations where you need someone to do some writing or to help you figure something out, it has to be a charitable organization. We can provide you with law students that you can oversee and mentor, and they will get continuing education credit. So give that some thought. All right, let's go now to the presentation since it's almost 11:30. The table of contents on page 24 from the book Gassman and Markham on Florida and Federal Creditor Protection Law may give you a good checklist for knowledge to have in this area. It is just such a far and wide topic. I try to update this book once a year. It typically takes me about 20 hours to read through it and update it every year, but that's how I try to stay current. I don't know what you do to stay current, but I know batteries get charged to stay current. Ha ha ha. All right, so I'm going to go now to page 100. And today we actually had the PowerPoint slides in advance, so we were able to get them to you. And on page 99, we have the Over Easy Parent LLC. And oftentimes clients will come to us and they have a successful company, which may surprise you once you meet the client. And the golden goose is in the company. So the golden goose may be a patent, maybe a trademark, maybe know-how, maybe a location. And the question is, if somebody slips on a widget and gets really badly hurt and has a $50 million lawsuit against the company, how do you resurrect the company? How do you save the company? And one good strategy, as we discussed last week, is to have the company owe money to its owners or to a related party or to a bank. So you could say, okay, I'll go borrow all I can from the bank and give the bank a lien on the assets. But the problem with that commonly is that if you borrow money from the bank inside a company and then pull the money out, you have to pay income tax, especially if the company is a C corporation, or often that applies to an S corporation. So what you can do is set up what we call a holding company. Now, it doesn't really hold you, like it's not warm and fuzzy, oh, hold me and I'll feel better. But it is the parent. It's above the subsidiary. So here we have creatively named this company Smith Holdings LLC. We have put it in Wyoming. We prefer Wyoming because Wyoming has good secrecy rules. In other words, you can't go to the Wyoming Secretary of State and find out who manages a company or who owns it. The Wyoming LLC can make an S election under the Internal Revenue Code, which is the most common way of ownership for business companies. And it can own the old company, creatively called Oldco. And the old company, which was an S corporation, becomes a qualified subchapter S subsidiary known as a Q sub, which works really well if it's a sandwich shop. So this is a tax-free maneuver. It's not free. We get to charge legal fees. Please remember to file an 8869 to make your Q sub election. Please remember to create minutes to satisfy the requirements of section 1.368-3, which I remember from law school. And then the Q sub keeps its tax ID number, keeps its name, keeps its identity, but the new parent company is the entity that will file the next tax return, taking over all of the tax characteristics of the Q sub. And now the Q sub, following state law, can, for good and valuable consideration, owe money to the parent company and give the parent company a lien on the Q sub's assets. So now, if the assets of the Q sub are worth $2 million and the Q sub owes the parent company $1.6 million, secured by a lien on the Q sub's assets, and there's a $4 million jury verdict against the Q sub. What happens? Well, usually the plaintiff lawyer says, give me $400,000 and your limits of liability, and I will gladly go away. But sometimes plaintiff lawyers aren't going to gladly do anything. They're going to be a stick in the mud. When that happens, the Q sub files a Chapter 11 bankruptcy and sells its assets to a related party as the highest bidder for, let's say, $300,000 in a bankruptcy court sale under Bankruptcy Code Section 363. Now, the new owner, which could be Mrs. Smith, who paid $300,000 and assumed the note, has no obligation to that creditor. The creditor gets the $300,000, except first the $300,000 is used to pay the Chapter 11 expenses. So you want to be ready for that type of situation. You don't want Smith Store Inc. to own all of its furniture, all of its equipment, its trade name, its phone number, all the non-competes from all the key employees, and the owners are so happy it's not in debt. Somebody slips and falls in the furniture store. It's so easy to see someone rack up $2 million in medical expenses and then a life care plan showing that they need to have $30 million set aside to pay for it. So this new parent over easy entity, here's the advantages. Number one, no need to change the name or tax ID number of the subsidiary. If it's a medical practice, you have to inform Medicare of the change, but there's no change of entity. So Medicare does not stop payments. The new parent can loan money to the sub. The new parent can own the life insurance for the buy-sell agreement. So here's Mr. Smith's revocable trust, and here's Mr. Other's revocable trust. They want to do a buy-sell agreement. They want to buy life insurance on each other. I don't like the life insurance being owned by the individuals because if one of them gets sued, you could lose the policy. I definitely don't want the life insurance owned by this entity, the operating entity, because then a creditor could take the policy. But here, the parent company could own the life insurance, should be insulated from the operations of the subsidiary. Now, we prefer to put the life insurance in a completely separate entity taxed as a partnership, but that is another story. All right. Number three, we talked about life insurance. Number four, the parent company can be formed in another jurisdiction. As I said, we like Wyoming, we like Delaware. Number five, it can be a tactful way to eliminate present ownership agreements or arrangements under the subsidiary. Hey, I don't like our buy-sell agreement. Let's do this new parent thing and do a new buy-sell agreement. Disadvantages, you got to pay a lawyer. Hopefully you'll use a lawyer to get this done. If you don't use a lawyer, it probably will not be done right. Then you have to maintain a separate LLC, but it doesn't have to have a separate tax return. And then you've got to tell the right people about it, like insurance agencies and things like that. So now I'm going to go to the first question at slide number 109, and I'm going to launch my first polling question. So I sure hope this works. I'm clicking on polls, and then I'm clicking on share. Is that what I click on, Brittany? And I'm clicking on share. Now, I don't know why that button doesn't say launch poll, but it says share. So now I've shared it. So now I see you're viewing this. And you said wrong one.
Yeah, you want to launch the one
Underneath it.
Are you interested in more information?
Oh, I'm sorry. All right. Launch. Did I get it right now? Okay. Sorry about that, everybody. I failed launching polls 101. Put that on the evaluation. Are you interested in more information on the NICE, National Institute for Charitable Education? A, yes, in which case maybe you could help us write, or you could help us find law students who would like to write. B, no. Or C, I wasn't listening. What is that? And that is a 501c3 organization that allows law students to do pro bono work for free, which they have to do anyway, writing for charitable organization and charitable purposes. Now, I have 88% of you have answered. The rest of you are obviously asleep. I'm going to hit close, but I'm talking about closing the poll, not the clothes you're wearing. Nothing about nudity in this presentation. Okay, so thank you for your patience. I hope we get the next one right. So my next example, and I'm sorry if I'm going too slow, but there's a lot of tax lawyers on this show, so we have to go slow for them. John owns his medical practice, and he owns the real estate partly under a family LLC, partly under a trust for his descendants. And then there's a triple net lease. So under state law, if somebody trips and falls in the medical practice, it's hard to get to the company if you have a proper triple net lease, and the state law limits the liability of a landlord if the lease is properly drafted. Hint, hint, have a qualified lawyer review your state law and the lease to make sure you have the magic words. In Florida, those magic words are: the tenant will have complete control, authority, and responsibility for the use and maintenance of the property. The landlord will not have any authority, responsibility, or decision-making with respect to the use or maintenance of the property. Okay? Then, now John would like to get money owed to him by the professional practice, but the CPA says, nope. If you do that, then you are limited to how much you can loan. You'll trigger income tax. You could only owe 800,000. Okay, so we'll set up a new parent, owe 800 to the family LLC, owe 500 to the new parent. So that is that. So next we're going to talk about equity stripping. And equity stripping is just a fancy way of saying that there's debt on the property. And what we would like to do, and it was easier to do when the interest rates were 2.5%, would say, hey, you have these 10 rental houses. They're worth $3 million. Why don't you borrow $2.5 million from the bank, put the $2.5 million in a variable annuity contract or your spouse's name or a limited partnership, and then if somebody sues you on the houses, the exposure is the $400,000 in equity. Well, now the client is going to face an 8% interest rate. So one way to do this would be to go to a friendly lender, and the friendly lender would give John $2.6 million. John would put the $2.6 million into an asset protection trust or an annuity or a life insurance policy. The friendly lender takes a mortgage on the property, and then the friendly lender takes a second lien on the asset protection trust or the life insurance policy or the annuity. So the friendly lender has almost no risk. By reason of having almost no risk, the friendly lender can loan at very low rates. So the friendly lender may be affiliated with the offshore asset protection trust. Although the whole thing looks like a lender from Delaware who has put conventional mortgages against the property. So if you think about it, there's really no money that came from the lender the way these are arranged. They are rare, but they are possible to do, and I just give you that as a example. Sometimes clients have assets overseas, and I try to warn them that the real estate rules in most jurisdictions outside of the United States can be extremely limiting and just downright dastardly. So if you own real estate in France or in the Bahamas or in St. Bart's, and you want to move that real estate to an LLC, you may pay a significant percentage of the value of the real estate to do it. Or in Canada, you will pay income taxes if you sold the property at the time of the transfer. So putting an offshore property into an LLC for creditor protection is often not possible. You may be able to do a nominee agreement so that it looks like it's owned by somebody else, but when push comes to shove, it's actually owned by the original person, creatively named Joe Bahama. So what Joe Bahama does is he sets up an LLC owned 90% by him and 10% by a trust for his children, and he agrees to pay that LLC $1 million by giving the LLC a note and mortgage. The note can be an arm's length note, so he's going to pay the LLC $50,000 a year. And now there's a lien against his offshore property. Now, he may take the 90% of the LLC and convey it to a Nevada or a Nevis creditor protection trust. So now if somebody comes after him and wants a financial statement, he'll show the offshore property, a $9 million mortgage against it, and either ownership of an LLC or beneficiary status under an offshore trust. Now, here's a question for you. When you fill out a financial statement for a client, and that client has set up an offshore trust, and the beneficiaries of that trust are the client's spouse and children, the client is not a beneficiary of that trust. Although the trust says that if the client's spouse dies or they become divorced, and the client's net worth goes down way below what it is now, then trust protectors under the trust agreement can add the client as a beneficiary. Do you have to disclose the existence of that trust on a financial statement or on a financial affidavit? And the answer, as you probably have guessed, is it depends. If there's really no likelihood, no significant likelihood that the client will ever benefit from that trust, then it doesn't need to be named. Otherwise, to be safe, you would at least put in the footnote that the client formed a trust for the client's spouse and descendants. The client can only be added to the trust under very limited circumstances. When a big mean lender finds out about that and sees that it was done well before the lender had an issue, and especially if this was on the financial statement that you gave the lender when you borrowed the money, then the big mean lender may say, oops, it's just too expensive to pursue that trust in Nevis or Belize or the Cook Islands. And we kind of made a mistake because it is mentioned on the financial statement in an asterisk. We had reason to know about it. We didn't ask about it then. I guess we ought to settle for the net value of the accessible assets. And we have seen that occur. In fact, we had a client who put on his financial statement, Alaska Trust, $2 million. And the bank loaned him money based on a financial statement that said Alaska Trust, $2 million. And he didn't ask us before he did it. I wouldn't have told him to do it. But then he got into trouble and the bank said, well, just pay us the $2 million from the Alaska Trust. And he said, I can't. That's in the discretion of the Alaska trustee. Here's a copy of the trust. See, I have no control over this trust. I set it up before I borrowed the money. I put it on my financial statement to make sure you would know about it. And the bank's lawyer said, but you didn't tell us that it was an irrevocable Alaska Asset Protection Trust. And he said, well, you didn't ask me. And the bank settled. And I think one reason was the bank officers didn't want to get in trouble for having made that loan in the first place. So let me go to polling question number 2 and see if I can do a better job of that. It's on page 154. For those of you who like round numbers, polling question number 2. And now I'm going to click the arrow down and let me see. I think I clicked it. I think I got it. Now I'm going to push launch, which it's almost launch time. All right. Now, I am on the diversity committee of the National Association of Estate Planning Councils. And while working with the diversity committee and brainstorming with Marty Shinkman and some other great thinkers, we came up with the idea of going to a law school and saying, hey, we will offer a fellowship. Provide us with one or more students, minority students, and we will provide them with a grant and the opportunity to join their local estate planning council, mentors assigned to them within that estate planning council, and a project, an educational project for the community relating to estate planning that will satisfy their pro bono hours. So we just got that approved with Stetson Law School. and it is now open. If you know any students at Stetson Law School, they may want to apply for it. My question is, would you or your estate planning counsel be interested in knowing more about this? The answer is A, yes, sponsoring a student to participate. B, participating in a diversity acceleration workshop. C, volunteering to mentor a student of color. D, the number we have dialed is out of service. And E, next question, please. And 72% did answer next question, please. But 4% are interested in sponsoring a student to participate. So I will be reaching out to you and appreciate your consideration of that project. I'm going to close the poll now by hitting the word close, which has nothing to do with what we're wearing. And I have now successfully done my first polling question without the help of my friend, real estate lawyer from Tampa, Matt Polling. Okay. Well, you've met my, charging order entities. So, may I have your order? Yes, I would like a charging order. Okay, well, what is a charging order? A charging order is what happens. See if I have a chart. There's a chart. There's the charging order chart. Say that really fast 10 times. When my spouse and I own 1% of a LLC or family limited partnership as tenants by the entireties, my spouse's revocable trust owns 96%, and a trust for our children owns 3%, and you get a judgment against my wife, Marcia. I don't know how that could ever happen, but you do. Now, what she owns is 96% of a family limited partnership. It may have $10 million in it. You go to the judge and say, hey, give me 96% of $10 million. The judge is going to tell you, no, sorry. Your sole remedy under the Florida statutes is a charging order. I will order Marcia to give you whatever she receives from that family limited partnership forevermore. But you have no right to force a distribution from the partnership, to take any management rights over the partnership, or otherwise. And you may, and I will say parenthetically, probably not, but you may have to pay income tax on 96% of the partnership income. That is your sole remedy, the charging order. And that was the subject of the court case of Wells Fargo Equipment Finance versus Redderith. Redderith lived in Florida, but had an Iowa LLC and was married to someone else in Florida, and argued that the judgment by Wells Fargo could not be imposed on the LLC because of Florida tenants by the entireties. And the Iowa court said, no, Iowa law applies, but Iowa does give you charging order protection. So the good news on this case, besides the fact that he has charging order protection, is that Iowa law applied. So, for example, you live in Texas or you live in California, and these states, Texas and California, and also Colorado, do not limit the charging order to being the sole remedy. They do let creditors take over ownership of an LLC interest. But that would be a reason for somebody who lives in California, Colorado, or another state that doesn't recognize charging order rules to form the LLC in Delaware or in Wyoming or in Nevada or in Florida, where we have charging order protection. Now, this is probably not the last word that we're going to hear on what state law applies. And it was probably significant that this LLC had assets in Iowa. But let me tell you, do you think other courts are going to disagree with an Iowa court? Iowa, I'm not being corny. Iowa is a well-respected state of the United States. So it will be interesting to see what happens as the world turns on this arrangement with respect to charging order protection. Now, Jay Atkinson, who I have a lot of respect for, and I always enjoy reading anything he writes, wrote an article on another case where a court got very angry at the part owner of an LLC and reached into the LLC and took assets and gave them to the creditor. And if you read Jay's column in Forbes, so you could just Google Jay Atkinson, and I don't know how to spell Atkinson exactly, but that's what Google's so great at, charging order Forbes. Jake sort of says that, hey, maybe charging orders aren't here to stay as the sole remedy. But if you read the case, the LLC allowed the debtor, after the charging order was put into place, to borrow money and give the bank a lien on the LLC assets. And the LLC also allowed the debtor to use the property. So I'm not going to be telling clients, hey, charging order, no problem. You'll still be able to use the property in the LLC. You'll be able to borrow on it. Nope. The best I can tell my client is you will have a stalemate. And most plaintiff lawyers that we have dealt with will settle for the limits as opposed to only being able to have the stalemate. But the next step, the next move on the chessboard for spouse 2 here would be whether she wants to convey her 96% limited partnership interest to a Nevada asset protection trust. Because while we don't know for sure whether a Nevada asset protection trust will work in the 30 non-asset protection trust states, we do know that even if it didn't work, the creditor's got to go to Nevada, suffer through that airport in Las Vegas, go to several gambling casinos, drink too much, get in trouble with their spouses, and then go to court, and then maybe be able to set aside the Nevada trust, but then they'll have a hangover. And then even if they win, all they have is a charging order. Oh, and by the way, if the trustee of the Nevada trust resigns, the alternate trustee is in Nevis. So then the day before trial, oh, sorry, we're not here anymore. We're in Nevis. Okay, then they got to go to Nevis, and on and on and on they go. So other things you may do. How about property with hazardous waste? I've had clients who said, well, I've got $1 million left. It's the only thing I've got. I found an old gas station. It's got some hazardous waste issues. I'm not afraid of them. I'll just spend my $1 million on the gas station. Oh, Mr. Bank, I have a gas station. Would you like to come take it? And the bank says, no, we'll just call you next year. We don't want to come and take your gas station. So, or maybe he finds a $10 million property, puts $1 million down, signs a $9 million note with an arm's length seller, and then, hey, bank, you want to pay this $9 million to get this property, or you want to give me a couple years to see how we do with this? Those two things may not be what they call fraudulent transfers that would get somebody into trouble. Now, whenever we get a new client, first, we're just surprised they hired us. Wow, thanks. But secondly, we want to see their operating agreements. And the reason we want to see their operating agreements is, first of all, so we can steal any really good clauses that aren't in our operating agreement. Second, create billable time. But third, and most importantly, find the problems. And I have to admit, more often than not, with any client, we will find a problem. And for Floridians, it is anything in an LLC operating agreement that will cause loss of tenancy by the entirety status. So tenancy by the entireties has 6 requirements. And Marcia and I have to equally own it. We took ownership at the same time. It takes both of us to divest it. We have equal rights. If one of us dies, it's instantly owned only by the survivor, etc., etc. Well, it's easy to draft an operating agreement that says, well, if Alan dies, Marcia has to jump up and touch her toes. Oops, that's not automatic survivorship, or the agreement could have any other provision that would cause loss of tenancy by the entirety status. If you're a licensed lawyer, send me an email. I'll be glad to send you our savings clause that we use for operating agreements for TBE. But even that's not enough. You've got to make sure the agreement is consistent with tenancy by the entireties. Secondly, we often, and this week I found it twice, we find documents that cause loss of the S election because of the second class of stock rule, which I was explaining to a healthcare lawyer this week, who said, oh, well, I've never had this problem. Okay, because you've never been audited. If you get audited, you're going to have a big problem. In an LLC treated as an S corp, you can't have capital accounts, and you can't have a buyout for less than book value as determined under generally accepted accounting principles. And you can't have distributions that are determined in any way other than by percentage of ownership. You could pay compensation as salary or through a management company, but my gosh, if you lose your S election, then the company gets taxed on its income like a C corporation, and then the shareholders get taxed when the income comes out. So that would not be a happy situation. So we want to be very careful. And I'll say number 5, I know most of the attendees are accountants, and yesterday I got an email from a client saying my accountant's going to form the LLC for this venture. How should it be taxed so that he does it right? I can't help him because it's called the unauthorized practice of law, and his malpractice insurance won't cover it. If I form the LLC and make a mistake, first of all, I hopefully won't make a mistake because I think I know what I'm doing. But secondly, an accountant who forms an LLC is much more likely to make a mistake and is breaking the law. So if I help him break the law, then I'm aiding and abetting the unauthorized practice of law. So give me a bad review because I can't do polling questions very well, and I muffed up the introduction, didn't show screen, and I said that accountants should not form, or at least should not prepare, operating agreements for LLCs. And a lot of times the client forms the LLC with the Secretary of State, but doesn't have an operating agreement. So then it doesn't qualify for certain advantages. So if you're an accountant, please, please, please tell the client you need an operating agreement. Go get one. You have to get it from a lawyer, or you can do it yourself. But here's the rules on doing it yourself. Number 1, the first rule on doing it yourself is if you did it yourself, it's probably wrong. Anyone who does his own legal work has a fool for a client. That's what F. Lee Bailey said before he went to jail for doing his own legal work. And then the third premise is that you can do legal work for yourself, but not for others. So if I go on to LegalZoom, I'm not a lawyer, and I do an LLC for myself, that's legal. But I do an LLC for my wife, or for my cousin, or for my client, well, that's an illegal act. So then, is an LLC formed illegally a valid LLC? Is a contract signed illegally a valid contract? My friend Steve Nielsen, Nillson, unfortunately not related to one of my favorite singers, Harry Nielsen, wrote an article for the Florida Bar Journal, which was very compelling, showing that a contract drafted by a non-lawyer in violation of the law may not be an enforceable contract. Okay, and as they say in law school, yada, 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 he got carried away, and as the mathematician would say, he got lost on a tangent. Okay, so speaking of quadrilateral, what are those called? Quadrilateral, not squares, rectangles. Let's go to the next polling question on slide 213. So I can hit click, 1, 2, 3, enter, and it's not there. 213, okay. So I can click, go 213, click enter. Here is the next polling question. I'm going to close down the arrow, and this is going to be, what book would you like for free? Now, there's a saying, nothing is free. Well, I'm going to change that saying, nothing worthwhile is free. So which of these non-worthwhile books would you like to have? Now, like an astronaut, and my father used to work for NASA, I have launched the polling question. And A, would you like creditor protection for Florida physicians? B, Grow Your Medical Practice, written with David Finkel, a best-selling Wall Street Journal author? 59% of you have chosen the 199A handbook. 31% have chosen 8 steps to a successful Florida estate plan. And while I see that almost 100% of you have voted, it only shows that 81% of you have voted. You notice that? Brittany, isn't that interesting? So even Go to My Webinar can't do math right. So I'm going to close the polling question. And now I've done 2 of them in a row without messing them up. And Brittany, do you recall what page I was on? Brittany was not listening and does not know what page I was on, because Brittany was not even alive when doctors used to have pagers. Remember that? They'd carry their pagers around before they had cell phones. Okay, now, it apparently is true, and from what I can tell, it is true, that Delaware does not allow garnishment on Delaware bank accounts. So I have had clients form Delaware bank accounts, and then they tell the court, they tell the creditors, hey, sorry, you can't garnish it. What are you going to do? Well, the creditor is going to pull the client in before the judge and try to get the judge to order the client to produce the Delaware account. But if you go to Jonathan Alper's website, ALPER in Florida, very bright guy, friend of mine, Harvard graduate. And even though he's a Harvard graduate, he's really smart. And he does write about these Delaware accounts, and he can tell you whether they actually work. Foreign accounts, there are a lot of jurisdictions that don't recognize U.S. judgments, such as the Isle of Man, the Cayman Islands, Nevis, Belize. So if you have an account there, it will certainly take longer for the creditor to reach the account, but eventually they will. Or they'll put you into bankruptcy and order you to repatriate the account. So unless you plan to run offshore and never come back, the foreign account may make clients feel better, but under an asset protection trust, you can argue, hey, you can't get this because it's an asset protection trust. I formed it not for the purpose of avoiding this creditor. I formed it before I knew I was going to have a creditor issue. And therefore, after bankruptcy, creditors may not be able to reach it, and the foreign bank account is therefore doubly safe. And don't forget that the penalty for not disclosing a foreign bank account on what they call the FBAR form and the Form 3520 can be 35% or more of the value of what you don't report. So there's some nasty, nasty situations. Now, there is case law, the Barber case and the Seville case, where the courts have gone back and forth on whether a U.S. creditor can seize the stock of a foreign company. And there's at least one case in a well-written opinion which says, hey, if you want to seize the stock of a Nevis LLC, you need to go to Nevis and get a judgment in Nevis to seize the stock. We can't do it from the United States. Well, Nevis doesn't recognize foreign judgments, so first you'd have to have a new jury trial in Nevis to prove to Nevis that the money's owed, apparently, and then try to seize the stock. So we do form foreign LLCs. They can be a way to make assets less accessible to creditors. You could have an IRA owned by somebody in a state where IRAs are not protected, invest the IRA into a offshore LLC, which then invests the IRA in conventional investments. That could be in Zurich, Liechtenstein, or right here in the United States. And the creditor looking at that situation is just not going to be able to get hold of those assets without a lot of hardship. And there's not much case law on exactly how to do it, because usually these matters go and settle. By the way, I have a question from a guy with a really good name. His name is Alan, and he says, will a foundation work? Will a Panama or Bahamas or Swiss foundation work? And the answer is they would work as well as an asset protection trust, in my opinion. And what is an offshore foundation? Well, in the 1930s or before, Switzerland, Germany, and certain other European countries have this organization, and it's really, I'm going to call it like a family foundation. So I form it, and it's like an amorphous organization for my family. No one owns stock in it. It's not like an LLC because there's ownership of stock, but it is like an LLC because there's a manager. And it's not like a trust where a trustee holds it with a duty to distribute it to family members, because with a foundation, there is no fiduciary duty. The only duty of the manager of a foundation is to make distributions only for the people in the family, and only if the foundation manager wants to. So it's not really an LLC or a company. It's not really a trust. So there's like nothing to grab onto. It's like I said, it's amorphous. There's no solid case law on creditors reaching into these, because nobody apparently has been able to. The tax law allows you to design it so that it can be taxed as a partnership. And New Hampshire and Wyoming have adopted statutes which allow these foundations. I'm sure if you Google Gassman Wyoming Foundation, it will, or New Hampshire Foundation, it will come up. And I think I mentioned a week ago or last week ago, and I apologize that the audio is going in and out. Somebody says the audios are going in and out. Actually, I just faked you out. I was not talking then. All right. So, I was going to say, California charges Californians $800 a year for the privilege of having an LLC anywhere in the country outside of California. But I don't think that statute applies to a foundation, and a foundation can own property and limit the liability of the family member beneficiaries of the foundation in the same way that an LLC can. Okay, we have 8 minutes remaining. And Brittany, do I have one more polling question? Okay, I'm going to do the one more polling question. It's at page 154. It's the polling question that everybody's been waiting for. It's polling question 3 of 4. Let me see. This is, okay. Would you, did I share it? All right. Would you or your estate planning council, if you're in one, be interested in A, sponsoring a student to participate, B, participating in a diversity acceleration workshop, C, volunteering to mentor a student of color, which I am doing, D, the number we have dialed is out of service, or E, next question, please. What is that?
5304 is the one you want to do.
I'm sorry, I got the wrong slide. 304? Sorry, I'm mixed up, Brittany. I'm going to slide 304.
Yes.
All right. I've got to scroll there because it's not letting me do my normal thing. 304. Okay, sorry about that. Well, 78% have answered. Are you interested in a free study group on the $50,000 IRA transfer to charitable remainder trust rule that just came out? If you're over 70 and a half, the 100,000 that you could give to charity from your IRA, you can now give up to 50 of the 100 to a charitable remainder trust that you and or your spouse are the lifetime income interest owners again. So A, yes, B, no, C, call again at your convenience, or D, I gave at the office. And again, I apologize, and I'm not very good at these polling questions. I promise to rehearse next time. All right, let's go back here, back to your childhood. Okay, I'm going to open up the discussion on foreign asset protection trusts. I talked about foundations. So I've got 5 minutes, which for a lot of you is 3/10 of a billable hour. And then I'm going to answer some questions. And thanks for the laugh out loud, Rob. You're always here and always supportive, and I appreciate that. Okay. What is a foreign asset protection trust? In the 14 and 1500s, the Isle of Man in the Irish Sea between Great Britain and Ireland was a banking island. And the king or other people could put their gold on the Isle of Man, and the Isle of Man would return that gold only to whoever brought it there. The Isle of Man did not recognize creditors. Fast forward 2023, take a flight to the Isle of Man, about 150 miles long, about 80 miles wide, a fantastic motorcycle race once a year, very friendly people, a lot of farmland, and a lot of trust companies on the main street. And if you form a trust in the Isle of Man, the trust agreement may say, I hereby deposit these accounts or these assets or the ownership of this LLC with the ABC Trust Company, which has been there 100 years. And the trust is for the benefit of my family, including me. But distributions will be made only in the discretion of the trustee, and no distributions will be made directly or indirectly to benefit anyone other than my family. Certainly not for the benefit of any creditor. Now, if you did this in the United States before about 1992, no matter what the trust said, to the extent that the trustee could give assets back to the contributor, a creditor could reach into the trust. That's just basic United States trust law. But that basic United States trust law, which has now been changed in 20 of the United States, most notably including Delaware, Nevada, Alaska, and South Dakota, are still out there. So the question is, if I go and I form a trust in one of the notable offshore asset protection trust jurisdictions, which in my opinion are the Cook Islands, Nevis, Belize, Gibraltar, and 2 or 3 others. If I form that trust before there are any issues, and I put a reasonable amount of assets in the trust, but I retain enough assets that I should never have to touch it. It should be for my children, grandchildren, and great-grandchildren. It may be my rainy day fund. I do it at a time when I don't expect to have a creditor problem, but who knows? I live in the United States. Now, something bad happens, a creditor gets a judgment against me, can they reach into the offshore trust? Could a judge put me in jail if I don't repatriate the assets of the offshore trust? Will Polly be saved from the train rails before the train comes and would run her over? This and many other things we will discuss in part 4 of our asset protection trust and asset protection discussion. But I will say that much less than 5% of the estate plans that we do for people who want creditor protection will involve a foreign asset protection trust because they're usually not needed. Nevertheless, if I do an asset protection trust in the United States, do I want to make sure that it could move offshore under certain circumstances? And the answer is probably yes. So that ends our hour. I am glad that you were able to attend. I'm glad that most of the attendees stayed to the bitter end. I think we've answered the questions. Jonathan Alper, A as in apple, L as in Louisiana, P as in Paul, E as in elephant, R as in ruffles have ridges. That's Jonathan Alper. He's got a really good website on creditor protection. Jesse, you said spank you very much. That's cute. No such thing as a free lunch. I agree, Adriano. And then I had a question. I can't really make it out, but you do have some slides here that go into further detail. I'll mention one last thing because I always like to mention one last thing. If you're in a tenancy by the entirety's jurisdiction, but you're afraid that both spouses will be sued, but you'd still like to protect them if only one is sued. Nevis, Tennessee, and Delaware, thanks to my friend Jonathan Gassman, have legislation which says that the asset protection trust formed there is a TBE asset. My right to receive distributions from that trust is only a right that would come to me and Marcia as tenants by the entireties. So that if you're going to do a asset protection trust for a married couple, which is rare but not unheard of, then you would consider Nevis, Tennessee, or Delaware. All right, well, thanks again. I hope if we enjoyed this presentation half as much as you did, then you enjoyed it twice as much as we did. I hope you'll use this information reasonably and carefully and to help others in a good way. Thank you.
Bye. It was nice seeing you.